The South African Bar Association is a voluntary association of LPC registered advocates operating nationally with its head office based in Enugu Center. With its membership drawn from all 9 provinces of South Africa, the association has seen rapid growth and is destined to become the biggest bar association in Southern Africa in years to come. The South African Bar Association is a LPC accredited vocation training provider and conducts pupillage training for aspiring advocates. The ongoing training and development of junior advocates and legal practitioners is a cornerstone value of the association, who thereby seeks to improve the quality of legal representation in our courts. The association's flagship afternoon programs have won the respect and support of the judiciary, academics, and practitioners alike. But most importantly, the association is committed to advancing the cause of female legal practitioners and is continuously exploring and supporting initiatives aimed at making this objective a reality. Membership of the association is free for practitioners starting off in the profession. It is only after the 3rd year of practice that a nominal membership fee is required. For more information, visit the South African Bar Association at www.rsabai.net. The South African Bar Association, transforming the legal profession.
Over to you, Advocate Fixer.
Good afternoon, ladies and gentlemen. On behalf of the South African Bar Association, we welcome you to our Thursday afternoon program. As you may well know, we host a speaker on a weekly basis to deal with legal topics that are intended to assist our practitioners or any other interested people, both locally and internationally, with the training and development which feeds into the core values that we hold as an organization. I have the privilege this afternoon to introduce our colleague to you, Advocate Motebang Ramaili. We know that he joined the bar in 2006. He was admitted as an advocate at the High Court of South Africa and the Superior Courts of the Mountain Kingdom of Lesotho. And he's currently working towards his admission as a barrister in Dublin, in Ireland. I'm going to hand the floor to my colleague, and he is sharing his intellectual capital today on the subject of when and how to bring an application in the Constitutional Court. So without much further ado, my colleague, Advocate Ramaili, please share with us on this topic today.
Sorry, Motebang, I think you muted.
I'm saying I truly appreciate Ronel for the introductory part, actually, that you've just spoken about me. And I truly appreciate a lot also on behalf of South African Bar Association to have given an opportunity to be presenting today. It's actually been one of those mammoth tasks that one will be doing today. But before I proceed, I just want to take to the learners of the audience the topics that I'll be talking about today. Specifically, I'll just have to give a brief background of the history of adoption of the Constitution of the Republic of South Africa. And then the second point that I'll be dealing with, it's how then you bring matters to the Constitutional Court, specifically in terms of application for leave to appeal. And I'll also be dealing with another aspect of direct access to the Constitutional Court. Now, one of the most important things that we actually cannot avoid in our own historical dispensation in the Republic of South Africa, it's two of the most important periods in the history of our country. Before 1994, you remember that South Africa was based in a principle called parliamentary sovereignty. What then meant was that the Parliament of the Republic of South Africa, as then it was the supreme law of the country, which have assimilated from the Westminster system of governance, which is England. Most of the Commonwealth countries used parliamentary sovereignty. So if then the decisions were then taken in Cape Town, in where the parliament is currently situated, and it was situated before 1994, it means everything and anything that we as a practitioners ought to respect the principles of parliamentary sovereignty. But after the unbanning of the political parties, specifically in 1990, we then saw a shift of the system in the Republic of South Africa. In principle, you would remember that there was an appointment of what we call a constitutional assembly. Constitutional assembly constituted of different political parties and members of the National Assembly by then, just before 1994. And then Constitutional Assembly then adopted what we call 34 principles, 34 constitutional principles. Out of 34 constitutional principles, that culminated in the adoption of interim constitution 200 of 1993. And then ultimately, then after recertification case, you'd remember there were two recertification cases in the Constitutional Court where the text of the Constitution was then judged against 34 principles, constitutional principles, and it was then returned back to the National Assembly to deal with to rectify the defects in before adoption of the thing of 1996 Constitution. And then in July 1996, then the final text for the 34 constitutional principles were then adopted in the certification case, where we then had what we call the final constitution, which is then called the Constitution of the Republic of South Africa Act 106 of 1996. It's also very important before dealing with the question that colleagues, you need to understand when you're dealing about the Constitution. Constitution is not an ordinary piece of legislation. Classical example, say for instance, like Criminal Procedure Act 51 of 1977 as amended, or any legislation that would have been adopted before 1994 and after 1994. The Constitution, it's a unique organic document that binds all of us, be the state, be the politicians, even us as a practitioners. In one of the earliest cases, actually, then Chief Justice Ishmael Mohammed, in State versus Mhlongo, one of the early Constitutional Court decisions had an opportunity to clarify the language of the Constitution. It said that you cannot actually, confine all this legalistic language in the Constitution, because it's a sui generis, generic document that you need to understand. When interpreting it, you won't necessarily interpret it in line with the ordinary provisions of legislative intention. Legislative provision, your text, context, and other likes. Now, what then becomes important and uniquely in the Constitution of the Republic of South Africa is the founding provisions of the Constitution. I don't have to talk much about that. But the most important provision of the Constitution, it's Section 2 of the Constitution, where it becomes quite clear and quite explicit to say the Constitution, it's a supreme law of the country. Any law or any conduct in conflict or inconsistent with Constitution shall be declared null and void, and obligations imposed by it must be fulfilled. So what you then understand in that language is that it's an aspect of law, it's also an aspect of the conduct. So every time and any time that you are dealing with the issue, you must always understand from the premise that it becomes a supreme law. What it then means that the common law, the customary law, legislation, all of them, they derive their force from the Constitution, which is the supremacy of the country. In rectification, in the pharmaceutical case, one of the earliest cases, that then Judge President or Chief Justice of the Republic of South Africa, Chuckelson, dealt with that aspect to say everything, we don't have different systems in the country, but we only have one system, which is constitutional supremacy, and everything derives from the Constitution. So if one was to have a regard of the parliamentary sovereignty and of the constitutional supremacy, even though we say the parliament, it's a legislative body of all three spheres of the government, also itself, everything and anything that is done, it has to be done within the conformity of the Constitution of the Republic of South Africa. That's a brief history and brief analysis that I wanted to make about the Constitution. And also what you also need to understand is when you are dealing with the Constitution of the Republic, there are principles that are actually applicable on a constitutional interpretation, be the Fundamental Bill of Rights, be any provisions of the Constitution. You do not necessarily, in classical example, when you're dealing with an ordinary legislation, philosophically, the most important aspect, you then have to ascertain the intention of legislation. By ascertaining of legislation, we know that you have to give that specific provision its own ordinary grammatical meaning within the context it's located, unless to do so, it then lead to absurdity. Other than that, is purposive interpretation. I'm not there about it. But the principles of interpretation of the Constitution, ordinarily you'd know that it's purposive interpretation and general interpretation or structural interpretation. It's all different together. It's not confined as how you deal with the legislation. So those are the aspects that I actually wanted to deal with in order for colleagues to understand what is an approach when we're dealing with the issue of the Constitution. Now, I want to narrow it back to what you call a constitutional court. I just needed to give a brief background of what happened. Now, when after 1993, in the adoption of the Constitution of the Republic of South Africa Act, Interim Constitution of 1993, it then culminated in the formation, or say in a better word, establishment of the Constitutional Court. The language in the Interim Constitution, so Constitutional Court was a Supreme Court, strictly dealing with the constitutional matters. And then the appellate division, which is Supreme Court, the current Supreme Court of Appeal. Supreme Court of Appeal was also the highest court of the land in any other matter except the constitutional matters. So it then created a conflict of the jurisdiction between the two courts, where you'd have a scenario where at what state do you then take the matter to the Constitutional Court or the Supreme Court of Appeal? Up until then came to the amendment of the Constitution, and then the Constitution of the Republic of South Africa then became what you call the apex court. So there were debates around members of the National Assembly and academics to say, should we change it to be should we change the name of the Constitutional Court to call it an apex court, or should we rather leave the name as a Constitutional Court? So the common consensus amongst those that in Parliament, or those that we call them politicians and academics, it was then agreed in principle to that let's then leave it as a constitutional court in the sense that it has been the name that was then established and it's established. People knew about it, but in a true sense, it's ought to have been called what you call an apex court, which is the highest court of the land. The of the constitutional court was then extended in terms of section 167 of the constitution, where you then set the constitution, of course, and then the constitutional court, it still deal with the constitutional matters, and then it's the highest court in terms of section 167, subsection 2. It still remained is the highest court in all constitutional matters. But what also became important in terms of amendment, it's that of a subsection. See where it says that it's a court connect. It may decide in only constitutional matters in the issues connected to constitutional decision, or also if, for instance, there's the point of public importance, then the constitutional court then can still hear the matter. That's how then the jurisdiction or the competency of the constitutional court was expanded. Now, after dealing with those issues, then you then ask yourself, now the second point that I also need to deal with, to say that how then do you bring the matter to the constitutional court? You have two options. The first option is a direct access to the constitutional court. Another one is an application for leave to appeal. I want to start with the first one, that of an application for leave to appeal. Ordinarily, in the courts of the Republic of South Africa, we then have what we call a magistrate's court. Magistrate courts will then consist of what we call magistrate courts will then sorry, colleagues, may I humbly request AJ to just put on the slides, if it's okay with you, colleagues. I'm sorry about it. So in magistrate courts, you have what we call a district court, and you then have what we call a regional court. You then have a situation where, for instance, if there's an issue of an appeal, I want to start with the lowest court because it's very important for one to deal with this aspect up until you get to the highest court of the land. So from either magistrate court, which is district court and regional court, it will then go to the high court, either in a review or in an appeal, of what we call a full bench consisting of the two judges. Or in another scenario, if the matter was then adjudicated in the high court, there will then be two options. Either leave to appeal, it will be before the full court consisting of the three judges, or it then go to the Supreme Court. And if for instance, it moves from the full court, it goes to the Supreme Court of Appeal. Of course, from a jurisprudence point of view, leave to appeal to the Supreme Court of Appeal, jurisprudentially, it's slightly different from how then you take it to the Constitutional Court. So if then one from the Supreme Court of Appeal, it will then go to the Constitutional Court, which is the highest court of the land, it's arbiter. Once you've taken a decision to once the Constitutional Court, your leave to appeal or either a review gets to Constitutional Court, it becomes the highest court of the land and it cannot be entertained. But you still have another scenario where people just want to parachute straight away from, say, for instance, and then you then have what we call a labor court. Of course, labor court, which is equivalent, it has equal status. It enjoys same status to that of the High Court, and labor appeal court will then enjoy the equal status to that of Supreme Court of Appeal. Though historically, we would know that labor appeal court did not actually enjoy the status that, but because of amendments, we were not there for that. It would then move to the highest court of the land. But you then have those scenarios at times where practitioners won't have a situation from the High Court, Labour Courts shoot straight to the Constitutional Court. What Constitutional Court has always been saying in many authorities, they would always encourage, philosophically, it's always important for all the courts, High Court, Supreme Court of Appeal, High Court, full bench, in the High Court, Supreme Court of Appeal, they must be given an opportunity to hear your matter, because it gives different opportunities in such a way that courts will then have a privy to say that what was the attitude of the judges when it comes to that aspect of it. That's another scenario that I also wanted to deal with it. So another point that I also want to deal with it, I've then dealt with that of what we call approaching Constitutional Court on application for leave to appeal. The most important rule actually it's rule 18, rule 19 of the uniform rules of the Constitutional Court, where it reads as follows: a litigant who is aggrieved by the decision of the court and who wishes to appeal against it directly to the court on a constitutional matter shall, within 15 days of the order against which the appeal is sought, be brought after giving notice to other party or consent lodged to the register, provided that where the president has refused leave to appeal for the period of prescribed. So what you then get on ordinary grammatical meaning within the context how this rule appears. So the approach of bringing a matter to the Constitutional Court, it's exactly the same. It has to be on a notice of motion together with the funding affidavit when you then take it to the Constitutional Court. So that's another aspect that I wanted to talk to about application for leave to appeal to the Constitutional Court. Another one is that of the direct access. Colleagues will remember that in the most recent times, in that case of the former President Jacob Zuma, the then acting Chief Justice Khampembe dealt with that aspect, where the legal team of the then president took the matter to the Constitutional Court. The direct access actually it's governed in terms of Rule 18 and 167, where an application it reads as follows: an application for direct access as contemplated in Section 167, subsection 6A of the Constitution shall be brought on notice of motion, which shall be supported by an affidavit and shall set forth what is it that the relief that sought. But in terms of Section 167, what becomes paramount importance, you then need to demonstrate that you are raising it's only at the interest of justice when the Constitutional Court then will hear you. But the advantage, like I'm saying, disadvantage of bringing a matter to the direct access is that once the Constitutional Court deals with the matter, it's final obiter, and you not necessarily go back to the High Court and bring it again. So that's what it says about Constitutional Court. What also another point that I want to make before I open up for questions is the High Court, Supreme Court of Appeal, and the Constitutional Court, they all can deal with any constitutional matter. But it's only the Constitutional Court that can confirm either the validity or invalidity of that constitutional matter. So that it's dealt with in terms of Rule 16 of the Uniform Rules, read with 172 of the Constitution, to say that what is it that is a constitutional matter. Confirmation of the constitutional invalidity in terms of Section Rule 16, it reads as follows. Rule 16 sub Rule 1 provides that register of the court which has made an order of invalid as contemplated. So Section 172 of the Constitution is quite explicit, is the one that quite clearly that gives them a direction how then you bring a matter for constitutional validity or invalidity of any act or conduct. Now the question is that how then you bring the matter to the Constitutional Court. Rule 11 sub 1 provides the mechanism how then you bring the matter in terms of the in the Constitutional Court. Without taking this matter further, and before I close, I want to just to summarize my presentation that I dealt with. I gave an overview of the distinction between parliamentary sovereignty and the constitutional supremacy. Why then we then shifted from parliamentary sovereignty to constitutional supremacy. There are 4 constitutional principles: adoption of the interim constitution, culmination of the thing of the 1996 constitution certification, and I also dealt with direct access and also application for leave to appeal. That's I would say that is a conclusion of my presentation. I'm sorry for being short. Unless there are other questions, I'm open for the floors for the colleagues to ask questions. Thanks a lot, AJ.
Thank you so much. You really symbolize the less is more principle. It was extremely informative for me as well, especially because the Constitutional Court is not a known comfortable territory for me. So thank you very much for that, and especially the background. I think the initial summary in the background is a good reminder of why we have our Constitutional Court and how that came about, and also understanding how it's measured against our other legislation. Thank you for that. If there are any questions, you can just raise your hand on the platform. I'll be able to see that. If anybody has a question, now's a good time for you to pose. I'm just running through it to see if there are any questions. Yes, Bart, if you would kindly put your camera on and your microphone. Let's hear it.
Right, forgive me, Ronel, my camera is not on because I don't have proper lighting where I'm sitting at the moment, so please forgive me. Councillor, thank you very much for your presentation. I've got a question that might appear not to be relevant to your presentation, but there have been concerns raised about, firstly, insofar as some of the matters that came before the Constitutional Court, that it appears as if the Constitutional Court is being used to advance certain political parties' political objectives, and that there's also this idea that there's this whole overreaching by the Constitutional Court into what is classically considered political or matters. Do you hold a view in that regard?
No, thanks a lot. One would say yes, also another one would actually say no. I'll give you an analogy. From a Christian point of view, one would say that the Bible, the Constitution is the Bible of the country. From an Islamic point of view, one would then say that the Holy Quran becomes a Quran of the country. So when one of the most important aspects of the constitutional interpretation, one of the principles, it's a structural interpretation or the historical interpretation. If you understand the historical interpretation of the Constitution of the Republic of South Africa, it says that when you interpret the Constitution, you then have to understand the history of the country, and then you interpret it. Now, if the Constitutional Court is the Supreme Court of the land, the Constitution of the Republic of South Africa embodies a principle like a German Constitution. We call it objective norms and the values, objective normative value system, on understanding that there are certain principles that we seek to achieve in the country. So if then we are living in a democratic country that allows one to express yourself through the courts, that historically understand that we're not necessarily given the privilege to deal with that aspect. So to answer your question, I would say that I do not think that the Constitutional Court has been influenced by certain aspect of political parties that or taking any shift towards any political organization, in the sense that it becomes a last obiter about the issues that are affecting the country, either from a political point of view or non-political point of view. That's how I can answer my question. I don't know if I got it right, my brother. I was able to answer you.
Thank you, Counsel.
Thanks a lot.
We have a question here from Eric Korta, and good luck with that. The question is, can I please ask who then holds justices of the ConCourt accountable if they do not apply the law accordingly, I think, or correctly? Yeah, what do you say?
Who do the constitutional, the judges?
Who holds them accountable? That's the question from Eric, if they don't apply the law correctly.
Yes. You know, to be frank, and be honest,
good luck.
Yes. So you see, it's in two ways. One would know that a Judicial Service Commission, it will then be a correct institution for one to hold a judge accountable for any wrongdoings or improper application interpretation, but mostly when you're dealing with the misconduct of the judge. But now, when it comes to the issue of the law of interpretation, say arguably you are faced with an issue of the legislative interpretation in line with the essential elements of the golden principle of interpretation of statutes, or you are faced with the issue of the interpretation of the Bill of Rights, where Constitutional Court then talks about generous and purposive. You are then faced with the any provisions, interpretation of any provisions of the Constitution, irrespective of the two, structural, historical, progressive interpretation. Now, remember interpretation, how one understands. So to answer the question, how, because interpretation is not necessarily a matter of fact. So one who cannot come to the conclusion to say that the judges at the Supreme Court at the highest court of the land, Constitutional Court, either they're interpreting law correctly or not correctly, either if, for instance, any form of interpretation, like indicated. So from an ethical principle point of view, a Judicial Service Commission would then be appropriate one. But when it comes to the matters of developing jurisprudence as a matter of interpretation, one has options to be given an opportunity in the future. Probably there's going to be a time, because let me give you a classical example, Ronel. You know, there are times where it was believed, I'll talk about interpretation of statute. There's a time where, in the early days, where it was believed that ascertaining of legislative intention, you remember that golden rule to say, literal interpretation is it's only one interpretation when dealing with the issues, others can fall. But with time, courts then developed and jurisprudence up to until so probably there'll be a time when in future correct the proper interpretation that is developed now if colleagues have a view that is not a correct interpretation. I really don't know if I answered, but that's how I can answer this question. I don't know if I attempted to answer it quite correctly.
I think so. I haven't heard anything further from Eric. I see Ahmed wants to ask a question. Ahmed, after you.
Thanks, Ronald. Thank you, Motebang. As per usual, your address is always insightful. Motebang, I'm going to bring you to to dissenting judgments, and I'm going to refer you to the memorable quote of Zuma's interview that was held in I think 2012 sometime, and he said, "How could you say that judgment is absolutely correct when the judges themselves have different views about it? There are dissenting judgments. You will find that the dissenting ones has more logic than the one that enjoyed the majority. What do you do in that case? And that's a quote from such an interview. Now, what is your opinion on that, Council?
You know, Jane, it's more of a philosophical question than actual legal question. There are two systems of the world. In the world, we have two judicial systems, legal systems throughout the world. You have those countries like who use what we call civil law countries. Germany, France, Holland, they don't follow the Commonwealth countries, you know, major and managers. I'm going to answer you. Where they don't have what we call a descending majority or minority judgment or dissenting judgments, in the sense that once there's unanimity, they take decisions, and that's what the law says. You can't have different views. The argument is it then brings what you call legal certainty in those civil law countries. I don't want to deal about civil law countries. I'm more trained in the common law countries. Now, in the common law countries, there's a debate around, even within the common law countries, there was a debate around this thing of majority and minority judgments. It then brings uncertainty about law. But why I'm trying to make this point, why I'm saying my viewpoint that I disagree with that instance is where, remember, law is not about who's right, who's wrong. You understand? The question is that who's more persuasive than another. We have many instances where minority judgments historically at later stage in our lives then became a majority judgments. So for me, it's not necessarily an issue. It's more philosophical issue, more political issue than legal section. Give an example. There's a case, I think it's 1950. I'll give you classical example cases. Let me give you an analogy of the case of delict. There are two important cases. Kruger versus Kotzie, it's a 1966 decision in delict. And then you have also Evels versus Minister of Safety and Security. Most of the majority judgments, they always conflicted the issue of wrongfulness and negligence in one aspect when it comes to the delict. But over some time, Evels actually clarified the issue so that there comes a time where you need to separate wrongfulness from negligence. It was if you were to look at the chronology of the cases as early as 1886 in Heaven versus Panda, that most of South African followers then came with the Donahue versus Stevenson, and many other cases that culminated in us coming to South Africa. So you have the situation where the courts were not persuaded in certain decisions were in minority, but later in time you find those minority judgments then become persuasive. One of the most classical cases where actually it comes to a statutory interpretation, the then Deputy Chief Justice or the Justice in the Appellate Division in 1952, Schreiner was conflicted. So the judgment of if I think it's Jaha, something JAR versus Dogs, something like that, when he dealt with the aspect of interpretation, as early as 1958, he was quite clear that literal interpretation, you can't interpret legislation in any provision in isolation, where a literal interpretation was literally that provision it's self-standing. But you then see later in the stage, after that, his minority judgment, now courts are then persuaded to say that when interpretation or looking at the interpretation, you look at literal interpretation within the context of purposive. Classical example, I mean, that quite a case law, I can show you a Natal Joint Municipality versus in Domain, it's 2012, Batu Bofma. It's that one of the thing of Batu Star Fishing. I can give you many of the cases. So it's really incorrect to say that even if minority judgments they make more sense now, then what do you do about it? the courts will then be given opportunity in future where they'll be persuaded that this minority, well, of course, minority judgments are persuasive and not binding. There'll be a time when the minority judgments now being persuasive and sure are going to be a binding authority. Yes, that's how then I can answer you, AJ. So in principle, I'm saying there are many instances where minority judgments in the near future, the Constitutional Court then the appellate division then or appeal court to say that, you know what, I think that minority judgment they were correct in that case law, then it becomes a binding authority. That's how then I can answer it, AJ.
Thank you
AJ,
so much.
You have, AJ. Thanks.
I hope I answered
You
you
have
well.
indeed answered. Thank you. You have. Thank you, Mr. Thank you.
From our colleague Romeo Ntabileni, he says, thanks for your informative presentation. What is your view with regards to the merging of the SCA and the Constitutional Court?
Yeah, it's a tough one, but I'll approach it from a comparative jurisprudential point of view, and to argue my proposition to say that I would not necessarily support the merging of the Constitutional Court and the Supreme Court of Appeal. I'll talk about it philosophically, and then I'll look at from a structural point of view how other countries are doing it. Of every many lives to, many appellate courts up to until the highest court. Supreme Court of Appeal. What is the advantage about Supreme Court of Appeal to this day is that it's a custodian of common law. I'm not talking about the common law from an English point of view, because remember, you would understand South Africa, when you talk about unique common law development of South Africa, you are talking about the common law that is unique and peculiar to us as South Africans, that we developed historically from the English and from the Dutch, and we merged them, we form our own unique common law. On numerous occasions and numerous judgments, you would have seen that Supreme Court of Appeal has actually become a custodian of the purest common law of South Africa as it was. Let's forget about the influence of the past regime. That's the first point that I deal with it. Now, and you then understand when it comes to Constitutional Court has always been, and it still is, a custodian of all constitutional matters and matters that are related to constitutional issues. So what is advantage about this thing? It then helps us to say, all right, when it comes to, say for instance, Section 39, subsection 2 of the Constitution, and Section 173 and Section 8 of the Constitution, it talks about the development of common law and development of customary law. So it gives one, of course, the High Court would then be the court of the first instance. So it allows one to have different views or different opinions for the hierarchy of the courts up to until to get to the highest court of the land. That's why you find most of the instances where, regardless, Constitutional Court, if we were to deal with the development of common law, Constitutional Court does not necessarily get it right better than the Supreme Court of Appeal. You then have instances where, when it comes to the issues of the constitutional issues and issues that related to constitutional matters, Supreme Court of Appeal does not really get it right. So for me, it's healthy for development of jurisprudence and understanding where we're coming from. It's premature for the merging of the two courts, strictly from a philosophical point of view. Now, if one was to do comparison to other countries, for instance, give an example. Why I had an opportunity to have gone to those. I had an opportunity to have appeared in Ireland, Dublin. I also have an opportunity also to appear in Mauritius. Advantage of those is we have different courts of the appeals, so that it gives an opportunity for the development of jurisprudence in such a way that not only one appellate court must have an opportunity to deal with the issue. So on those bases alone, on comparing, for me, it's still, because you know, in Germany, Yeah. So I still believe that it's still soon for the two courts to be merged. That's my view about that. Why I do not support the merging of the Constitutional Court and the Supreme Court of Appeal. That's my answer to that. I don't know if my Judge Ntambelena was able to answer you quite correctly. What I don't support the merging of the two courts.
Sorry, could I ask our one of our delegates to mute the microphone, please? We have a question from July Manisi, and he said, given that the ConCourt is the final arbitrator in all matters, can its decisions be challenged at the African Court on Human and People's Rights if they involve violations of human rights?
All right. Let me answer by this. Yes, that can be done. But what you then need to understand when it comes to African Court of Justice or African Court of Human Rights and some of the two courts is South Africa, you then have to be a signatory. It's a competence of the jurisdiction of those courts. You don't automatically have a right or say to take the matters directly to there. You can take the matter to the African courts of ours. I had an opportunity in October 2021. I was in Dar es Salaam involved in one of those commercial matters there in that court. So yes, you can and take it to African court, but you must understand the jurisdiction of the competence of that court. It's not automatic like that of your Supreme Court of Appeal of the Constitutional Court, in the sense that South Africa ought to be signatory to that court and also have a legislation that given effect for it to be heard on that instance. So to answer you, yes, you can take it to if it's a issues that are dealing with the human rights issues, South African Court of Human Rights, African Court of Human Rights, something like that, and also other commercial matters, you can then take it to the African Court of Justice. Yeah, that's to answer you, yes, you can.
Thank you very much. I've kept my eye on the chat box, and there's a big thank you there from Sipuma. Thank you for your presentation. I'd like to know your view about the recent Constitutional Court and Supreme Court jurisprudence regarding the interpretation of wrongfulness, and whether wrongfulness in its traditional sense should be one of the main determining factors, or a more modern wrongfulness principle, whether that should be acceptable.
You see, Ronel, that's a principle of delict. I'll talk about within the confinements of delict. One of the earliest cases in the Constitutional Court that dealt with, remember, what Section 39, subsection 2 of the Constitution says. When interpreting any law or developing common law, customary law, the courts when interpreting any law, must promote the spirit, purpose, and object of the Bill of Rights. That's what 39.2 says. I'm going to answer you. Section 172 or 173, to be precise, 173 of the Constitution, it says, High Court, Supreme Court of Appeal, Constitutional Court must develop common law at the interest of justice. You then go to, I think it's Section 8, subsection 3, where also the Constitutional Court says that you must also develop a common law. I'm mainly saying this because remember the principle of wrongfulness, it's a common law principle. Now, the courts were actually silent about how then you come up with the development of common law. One of the earliest cases, there's one case of Kamichel versus Minister of Safety and Security. You have the High Court one in the Western Cape, then you Commission 1 in the High Court, we have Commission 2 in the Court of Appeal, we have Commission 3 in the Constitutional Court. Commission 3 in the Constitutional Court becomes the most important one. I remember it was in the early 2001, and I don't remember the citation quite well. It was then the then Justice Chuckle, Ackerman was the one that gave a majority judgment in that case, where the Supreme Court of Appeal High Court failed to develop common law. Supreme Court of Appeal declined to develop common law. Now the issue was, if the common law is defective, does not promote, it should always be clear that our constitution embodied the principle called objective norms and the values. We call it objective normative value system, like that of the Russian constitution, German constitution, that of Canada constitution. So when you're talking about objective norms and the values of the constitution, so we are saying that we are transforming our society from how it was and to that of the values. So lawfulness has to conform to objective norms and the values of the constitution. It's another topic that we did about anyway. So then Chuckleson said in the State versus Commission, he gave two options to say that how then do you develop common law? He says there are instances, we call it, academics, they call it indirect application, where if, for instance, wrongfulness as it stands, it does not conform within object norms and the values of the constitution, then there's a need for one to develop that common law to be empowered in the constitution. Other aspect was that even if it conforms to the values of the constitution, but there's a bit of defect, then you must promote it. And then there's another case, State versus the Bus, where it was a criminal matter that dealing with the common purpose. The then Deputy Chief Justice Rifamo Seneke was the one that was penning the majority judgment. He talked about it. Now, to answer your question, for me, in the most recent application of the thing of the Constitutional Court, when it comes to the understanding of the interpretation of wrongfulness, it's quite important, and I support it, because remember, when you're dealing with the wrongfulness, unlike negligence, remember, ordinarily negligence is always determined from a factual point of view. It's always prima facie wrongful. It's easy to prove negligence, but wrongfulness, in either in a context of unlawful arrest and detention, in a context of medical negligence, in a context of unjustified enrichment, in any form, it's usually a judicial determination. Either you approach it, because remember, wrongfulness, you can use it either when on the determination of the breach of subjective right, breach of any constitutional right, and also an omission. So I fully support the approach of the Constitutional Court when in regards to the approach towards an interpretation of wrongfulness in such a way that it's more of a judicial determination than a factual determination like negligence. So in principle, yes, I support. There are many case laws that came after that I support the most recent interpretation of how Constitutional Court came. Because remember, wrongfulness, jurisprudentially, from a constitutional jurisprudential point of view, you don't interpret it, you develop it. The language that is used by Constitutional Court as early as I can remember, is a development, not interpretation. The language that is used by the Constitutional Court, even that's why you develop. Common law, wrongfulness is not interpreted, it's developed. That's a philosophy that is accepted by the court. I hope I was able to answer that question quite well, Ronel.
Thank you so much. I'm starting to feel a little bit like Oprah Winfrey here. So here's one for you from Sonwabile Matilose. He says, what's your view on judges being appointed by politicians, i.e. the fact that they sit in the JSC panel and after which the appointment will be confirmed by the president? Does it not in a way interfere with the separation of powers principle, which our constitutional preaches? Is it healthy for our jurisprudence? And this is a call for your view on it. Be interesting.
You know, about, I think was it last week or early this week, I had a discussion with Judge Ntambeleni. We just had informal discussion telephonically about this issue. You know, to be frank and be honest with me, I honestly do not support the politicians forming part of the thing, being part of Judicial Service Commission, in the sense that, I mean, if one was to have a regard in the most recent interviews, they were not necessarily based strictly from legal jurisprudential point of view, where they were also marred by the politicians and the decisions that were there, they're not part of the case. So in principle, I don't support the politician forming part of Judicial Service Commission, and also that candidates in the appointment of the judges, because it defeats the whole objective of the values that Constitution seeks to achieve, and independence of the judiciary. That's how then I can answer it. In principle, I do not support it. Unfortunately, that's what the Constitution no.
I've got that. Thank you. Well battered, Motebang. Well battered. Thank you very much. I see that we're drawing to a close. There's a question that just popped up. If I can show that quickly. Oh, that was a thank you from Mabili. Thank you so much. Yes.
Before I close this out, you know, Chief Justice, the late Chief Justice Ismail Mohammed. You know, there's a language that she used to say, Are, you must try by all means, every practitioner, it becomes incumbent about every practitioner to understand the norms and the values that the Constitution seeks to achieve. That's it becomes the norm of every practitioner. So Chief Justice was always clear when it comes to that. That's the principle that the Bible becomes our own Quran, becomes in other aspect, Christians will say their own Bible. That's what I wanted to say in closing.
Yes.
Thanks a lot.
Thank you, Motebang. Thank you very much. I have encouraged my pupil to join these conversations as well, and take it to her fellow pupils, purely because what we see here is education in action. And I think the questions that we are getting from our delegates illustrates that dynamic. And it's amazing the way that you've shared your intellectual capital with us. May I ask that the references to the cases, the citation of the cases that you refer to, if you wouldn't mind letting us have that, if you could just send it through.
Yes, I'll assist.
And so that, especially for us colleagues that are not as au fait on the subject, that we can just extend our new knowledge a little bit further. But for your time especially, and bringing your knowledge and expertise to us. And yes, it sounds like you travel to exciting places. And if you go to Dar again, give us the heads up. We'll see you there. Thank you very much. Thank you, Motebang. To all our delegates, of course, you'll see that I posted the link for the recording on the chat box. You can take a look at it again. I know I certainly will. And remember that it's every Thursday, this time from 4 to 5. And go and look at the previous discussions, and especially to our pupils. Make sure that you try and get to our Thursday afternoon sessions and learn something a little bit extra while we're all at it. So from the SA Bar Association, thank you everybody for participating today, and we'll see you next Thursday, same time, same place. Have a lovely evening.
Thank you.
Thank you.